the main issues here, the main things you're trying to suppress are basically what?
Well, what we're dealing with today is some alleged statements, inculpatory statements that Michael is supposed to have made while incarcerated at Mid-Orange Correctional Facility to a couple of inmates who were conceitedly police agents at the time and who were put in contact with him in an effort to get him to make some admissions.
Now, your statement that you're making here is they're police agents, so something, you know,
right.
Why, if it's stipulated they're police agents, then why is it then that evidence or that testimony shouldn't be included in a trial if it goes to trial?
Right. The stipulation that they were police agents gets me maybe halfway home on my argument that Michael's right to an attorney was violated while he was incarcerated at Mid-Orange Correctional by these police agents who the law says, if they are agents of the police, they have to conduct themselves like the police do and pay attention to Michael's Sixth Amendment right to an attorney, and they didn't do that, obviously.
Now, was he really getting pumped for information during these few months period that he was staying with Mr. Ryan in the cell, do you think?
No question about it. I think it was probably pretty much a daily occurrence that Mr. Ryan was trying to get information from John and pass it on.
As far as the talk about, like you said, the extension cord, those were also issues you brought up here. You wanted to make very clear that you got everything on the record.
Well, I think the judge was wanting to restrict me somewhat by virtue of the fact that Ms. Mills stipulated to the agency issue. But the case law on the issue tells me that I needed to build a little better record of exactly what went on between Ryan and Mike Foster while Ryan was working for the police.
How difficult is it to kind of maneuver around this and try to get these particular statements thrown out?
What we've got, and Christy and I both talked about this, is we've got pretty much a legal argument. The facts are pretty much what they are. It's going to boil down to the legal argument of was Michael's Sixth Amendment right to counsel violated by these two police informants. Right, the stuff in the morning was kind of throwaway stuff. It was, if you noticed, there wasn't that much that was inculpatory. The strange thing in this case is Michael is interviewed repeatedly by all kinds of police. He gives 3 written statements and numerous oral statements, and he doesn't admit this murder to anybody who is a badge-wearing law enforcement officer, but allegedly only admits it to 2 snitches in state prison.
Maybe because he felt he was safe? I don't know.
I think he had the tendency of everybody going into state prison to brag, and he did brag to John Ryan. When you get into the state prison system, you want everybody to think that you're a killer and you're tough, and I think there was a lot of that braggadocio going on, for lack of a...
Well, what is Michael, if anything, if you can tell us anything, indicating to you about all this? Is that what he's classifying this as or characterizing this as? That I would just talk it up a hype so I could be better off in prison?
As 99% of, I think, the inmates, when they get into the state system do, they talk themselves up as being big, tough guys. John Ryan, while he didn't admit to that on the stand this afternoon, did admit to that in the deposition that they took from him, that he felt Mike was blowing his own horn, trying to look like a tough guy. And it's a protective mechanism when you get into the state system.